XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. The United States Securities and Exchange Commission, SEC, has dismissed charges against Ripple Labs leaders Chris Larsen, chairman and co-founder, and Brad Garlinghouse, CEO. Plaintiff, SEC, respectfully notified the court of the stipulated dismissal of the SEC's pending claims against defendants Christian Larsen and Bradley Garlinghouse, according to a recent court brief. Notably, the court made this clear in a briefing yesterday by pro-XRP counsel James K. Phelan. The news sparked responses from the XRP community, with Ripple close Stuart Alderodi commenting on the SEC's decision to drop the lawsuit against Larsen and Garlinghouse. In a statement, Alderodi said that the SEC made a mistake in going after the company's executives, which led to the company's surrender. Surprisingly, Ripple's chief legal officer referred to the action as a capitulation by the SEC rather than a settlement. Other XRP followers, in addition to Alderodi, responded to the news. According to one expert, the regulator withdrew the accusations because it did not want to lose for the third time in a row. Remember that on July 13, the court found that most XRP transactions that the SEC claims are securities are not. The court also refused the SEC's attempt to certify an interlocutory appeal. Notably, the court's decision on the April 2024 trial might have been another crucial decision in the case. The dismissal of the lawsuit is a significant victory for Ripple, causing the price of XRP to surge dramatically. According to CoinGecko statistics, the price of XRP increased by more than 10 in the aftermath of the announcement. Interestingly, XRP rose to a 24-hour high of $0, 528, from a low of 477 cents. At press time, the currency was trading at $0, 512, up 6.3 in the previous 24 hours. The SEC first charged Garlinghouse and Larsen with assisting Ripple Labs in breaching securities laws via the selling of XRP to institutional investors. As previously reported, the court concluded on July 13 that Ripple's institutional sales qualify as investment contracts, but sales to ordinary investors do not. As a result, the court ordered the SEC's case against Ripple executives for a jury trial in April 2024. With the SEC dropping the accusations against Garlinghouse and Larsen, there will be no trial in April 2024. The SEC will work with Ripple to establish the proper remedies for the company's breach of securities laws via its institutional sales. Following the remedies stage, the SEC might launch a complete appeal of the case, contesting the court's findings on programmatic sales and other distributions. Furthermore, the SEC might reach an agreement with Ripple and stop the multi-year legal struggle. So yeah, the agency has not indicated any preparations for a settlement. It seems to be planning to challenge the court's July 13 judgment, which defined programmatic sales and other XRP disbursements to be non-securities. Social media has become a battleground in the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission, SEC, with some users arguing that the latest court verdict will have little to no impact on the cryptocurrency industry, while others are vehemently to the contrary. An ex-SEC attorney, John Reed Stark, called the recent rejection of the agency's move for an interlocutory appeal by Judge Annalisa Torres a Pyrrhic victory at best for the XRP team in an X post published on October 6. After the trial, the governing body will still undoubtedly appeal the decision, and I believe have a good chance of winning, Stark says, since the judge has specifically deemed her decision as not precedent for the rest of the cryptoverse. Moreover, he disregarded the most recent judgment by Judge Torres as precedent on the issue of whether tokens are securities, saying the court did not hold that offers and sales on a digital asset exchange cannot create a reasonable expectation of profits based on the efforts of others. The former attorney for the SEC specifically stated that the court held that based on the totality of the circumstances in this case, including an examination of the facts, circumstances, and economic realities of the transactions, Ripple's programmatic sales could not lead investors to reasonably expect profits from Ripple's efforts. Emphasis in original. agree to disagree on the legal impact of Judge Torres' rulings, but you also seem to be saying that XRP uniquely stands as the only digital asset, other than BCC, with judicial clarity as a non-security. Stuart Alderodi, the chief legal officer of the blockchain company, responded to Stark's post. We're on the same page now. Attorney Jeremy Hogan simultaneously listed multiple potential outcomes for the Ripple v. SEC case after the judge denied an interlocutory appeal motion, including the regulator proceeding with a trial next April against the individual defendants and an appeal of the case no sooner than 2025, with an appellate ruling no earlier than 2026. Alternatively, the SEC may settle all litigation against Ripple and the individual defendants at a settlement conference on April 16, 2024, or it may proceed with obtaining a final judgment against Ripple and then appeal. On 6 October 2023, John Reed Stark, a regulatory compliance specialist in the digital arena with a 15-year stint as an SEC enforcement attorney, turned to social media platform X, previously known as Twitter, to offer his thoughts on Judge Torres' recent ruling involving the SEC and XRP's recent ruling involving the SEC and XRP. Stark underlined that the judge's decision to deny the SEC interlocutory appeal also said that her earlier summary judgment should not be treated as creating a legal precedent unless the circumstances of a new case are similar. Stark pointed out that although this may seem to be a little success for the XRP team, it might ultimately be a hollow victory. He expects that the SEC will appeal the verdict after the trial and will have a decent chance of prevailing. Judge Torres has specifically said that her ruling is not to be regarded a precedent for subsequent lawsuits in the Bitcoin industry, according to Stark. Stark also praised John Deaton and the XRP team for opposing the SEC's unilateral law-making techniques. He stated his displeasure with attorneys who switch between law firms and the SEC, implying that such lawyers are unlikely to question the existing quo owing to possible conflicts of interest. Stark applauded Deaton's team for spotlighting the SEC's unappreciated efforts in fighting less publicized but critical issues like microcap fraud and penny stock fraud. However, Stark was emphatic in declaring that Judge Torres' ruling on Ripple should not be regarded as a precedent on whether coins are securities. He emphasized the judge's unequivocal statement that her judgments were based on the Ripple case's unique facts and circumstances. Judge Torres rejected the SEC's assertion that the issues posed in the case are crucial legal issues with far-reaching repercussions for several other cases in her judgment, denying the SEC's motion for interlocutory appeal. She stressed that her judgments are based on applying the Howey test to the particular facts and circumstances of this Ripple instance. Judge Torres went on to remark that the SEC's references to previous enforcement proceedings involving various digital assets and firms are not directly comparable owing to differences in facts and economic circumstances. She also corrected the SEC's interpretation of her findings, indicating that her order should not be seen as creating a precedent for subsequent digital asset matters. The SEC had specifically tried to determine whether an issuer's activity on cryptocurrency trading platforms may establish a reasonable expectation of gains for investors. Judge Torres noted that her decision was not a blanket pronouncement on the subject, but was based on the whole set of facts and economic realities of Ripple's programmatic sales.